being devoted to a particular business, is you can look at that particular business for more regulations or more inspections and send more people out and just consider that part of the public safety work. That's what you're here to do.
But we can't with that settlement agreement. We're going to have a tough problem with any regulations.
That's the one part of the consent judgment settlement agreement that I mentioned earlier that I thought was problematic. The regulatory war, though, is not over when it comes to this type of business. And this is probably going to come off as a bit aggressive for the analysis, I guess, from outside counsel. But if the City of Lincoln Park identifies, I don't often get to it. I like to lean back away from it. If the City of Lincoln Park were to identify a particular regulatory objective with regard to this business that was the subject of the lawsuit, and let's say it was the dancer platform or the 60-inch rule or one of the licensing regulations or perhaps a new regulation that we haven't even thought of yet that you thought was really important to have put in place, I'd go back to them.
Can I ask you why?
I would reopen, and I want to be careful how I explain this, because the reality of a situation like this in the settlement agreement is it can be modified. So if in the Lincoln Park experience there was a provision in here that really seemed onerous to the city over the course of the next couple of years, let's say that platform or the 60-inch distance really became a big issue, a really big issue for Lincoln Park. There were problems in that business because people were too close to each other and there was groping or fondling. You had repeated reports and they weren't controlling it. Then I'd go back. I wouldn't take this as slam the door on the City of Lincoln Park. You can never do anything by way of ordinance regulation again. I'd go back and say, folks, we want to do it.
Can I ask you why you thought that was a big loss to us, giving away that portion? Because
go ahead.
I kind of thought I was more concerned with hiring pedophiles in the background checks. My concern was a little more stressed there than even so much that, because at least that's adults in there. Much I don't like it.
Yeah, I'll answer it in real blunt, candid terms. The people that are in the adult business sector don't like that regulatory type provision because it cramps their business. And it is one that helps reduce the behavior on site that folks kind of hope doesn't occur, the groping and fondling type stuff. The separating the patrons and the performers limits that type of behavior. So it's it's a good regulatory provision to have from a municipality standpoint. It's a bad one from one of those business standpoints. They don't like to have to deal with it. Right. And in this particular case, you can see that was one they negotiated away, and that's a loss. But anytime you have litigation, an agreement, and a settlement, there will be some gain and some loss. In a perfect world, you wouldn't lose that, but.
Do you think we should rescind our public nudity ordinance? Because, I mean, it's almost a moot point. It just gives rise to challenge it, if you ask me, because it's so unenforceable.
Yes.
Thank you. But I've been saying this since the time of adoption. I felt it was no good at the time that this council put it forth.
I wouldn't say it is no good. The ordinance involved a public statement by the City of Lincoln Park that nudity was prohibited. In and of itself, that public statement as a public policy statement probably reflected the values of your community. I don't think there's anything wrong with that. The enforcement of it and the criminal penalty of it, if the federal courts say you can't do that, then you can't do it. Right. And leaving it there after it's been found to be unenforceable, not in this particular case, but in the Southgate case, leaving it there on the books creates confusion and anxiety. So short answer to your question is you should probably repeal it. And if there's going to be another one of some form, needs to be researched carefully, and you would have to examine whether or not something more along the Grand Rapids pattern would work better. And then if that's really where the City of Lincoln Park wanted to go, and if there was a question as to whether or not the settlement agreement and consent judgment might bar it, then I'd hit that one head on.
May I ask you if
Yes.
if we had contested and held our ground, as it pertains to the adult cabaret licensing procedure, how do you think we would have fared out according to case law in other cases that have done similar licensing procedures? It's a guess. I'm just asking.
No, I'm just trying to make sure I answer it correctly. And I wouldn't just guess. It's kind of like asking what would have happened if I'd pulled the starting pitcher in the 4th inning instead of waiting till the 6th. But the only provision in there that I think that the city may have had a chance at keeping that was given up. Of course, it was given up in the course of negotiation as opposed to a court ruling, but the dancing platform and proximity one, I think you had a shot at keeping. But that's the Monday morning quarterback, or the, what did Billy Martin call it? He said he was a first guesser, and everybody else on Monday morning is a second guesser. So I hate to kind of go down that line, because what you have was a difficult situation, a difficult lawsuit, a difficult business to deal with. You have a settlement agreement, and I really think the City of Lincoln Park needs to be going forward in coping with it and getting on to other regulatory issues, much the way you already are. You're a step ahead of me in that, because you've already started looking at what else is left, what else can be done, how can we minimize negative secondary effects.
That's my main objective.
And I commend you for it, because that's the right direction. And it's the only direction municipalities really have when they go through these lawsuits, is when one's over, we now have to look at what we have for businesses, what we can expect for new businesses, what we can do for regulations. If we have some that didn't work so well, live and learn, scrap those and start again. And you're already on that. You're already on that track, and that's the one to be on.
Can I ask you, was a lot of your opinion based on the fact that there was really no monetary settlement against the city? When there could have been cost for litigation, there could have been a settlement. Was it a lot to do with financial aspect of it?
It was a significant factor that the city didn't have to spend a bunch of money, and you're not going to be subjected to a long litigation process that would cost you money, or perhaps be difficult for the city council. There were some suggestions that individual city council people could be named, and claims of unconstitutional behavior would be brought.
That's a lot of hype, though.
There's
a lot of hype in this
It
hot
usually
lawsuit.
is.
Yeah.
But avoiding that stuff, if you avoid it by way of a settlement, is always worth something, even if it was hype. More so than the monetary exposure, or the exposure to monetary damages, I think Lincoln Park became entangled just a little bit in this interplay between House Counsel, Defense Counsel, Insurance Defense Counsel, and no outside counsel. And I in no way intend that comment to be critical of Mr. Zelenak or Mr. Tam, but what I see sometimes is that plaintiffs' counsel, in representing adult businesses, will formulate one type of a complaint in theory of lawsuit. I've stopped looking over this way. I'm sorry, folks.
Okay.
I've been responding to her, and I've forgotten to look over at you folks. I'll try and do it more. Plaintiffs' counsel, I think they must go to some training and learn to do this, where they develop one claim against a municipality that will include claims for monetary damages as well as declaratory relief, or injunctive relief. And they will trigger some involvement of Insurance Defense Counsel, and then they will modify their complaint and take the damage provisions out. And then it becomes either unclear or less than clear as to the role of Insurance Defense Counsel. And you end up then with a funny mix of House Counsel, Insurance Defense Counsel,
Covering who?
and maybe, if the stakes go up another notch, and Insurance Defense Counsel isn't going to cover us all the way through because there's no longer a claim for monetary damages, then maybe we need to bring in outside counsel who specializes in dealing with these. And then you've got House Counsel, Insurance Defense Counsel, and outside counsel, and you're you know,
Big mess.
yes. And I believe that this is a tactic sometimes employed by plaintiffs' counsel in the adult business arena, and that's not being critical of them. Maybe it's even praising them for their tactics. But it leaves a municipality sometimes not particularly well prepared to deal with that, because then you have a little bit of a question of who's sailing the ship. I noticed it in this case that I think some of those factors were present. I've seen it several other times. And I just think plaintiffs' counsel gets a little bit of mileage out of it. And then communities are unsure how far they need to press it because they don't know if they're going to have to go bring in another lawyer, or if Insurance Defense Counsel is going to take care of it, or if their House Counsel is going to take care of it. And it just gets hard to keep track of. And there's a little bit of that in your situation here.
Well, since we're talking about that a little bit, it has been my stance and my belief, and council has, by a majority vote of council, said that we did not authorize the signing of that settlement agreement. And there has been 4 of us that have passed a resolution, and it's in our official record of the city, stating that we did not authorize the signing of that agreement, nor could we have in closed session, nor had we even had seen it at that point. And I know you and I had discussed somewhat to the effect that there would possibly be an Open Meetings Act violation because of that, because it's never come in front of this council. And I wish you would elaborate just a little bit on that and the authorities of signing documents by municipal city council.
I'd be happy to. The Open Meetings Act issue is a touchy one for municipalities, but the law is pretty plain. As compared to the whole field of adult business regulation, the Open Meetings Act is...
not as confusing.
Right. I'm going to just quote a couple of provisions. The general rule of law is that an attorney is not automatically authorized to settle a case. The almost unanimous rule laid down by the courts of the United States, both federal and state, is that an attorney at law has no power by virtue of his general retainer to compromise his client's cause of action, but that precedent, special authority, or subsequent ratification is necessary to make such a compromise valid and binding on the client. Broad general statement. There's a more particular one for municipalities. A municipal attorney does not have independent authority to enter a consent judgment for a municipality. And then this is a quote. As a matter of law, a city attorney does not have the independent authority to enter into any type of consent judgment or settlement without prior approval of the appropriate city authorities. That's black letter law from within the state of Michigan.
And you're reading, what is that you're reading, the Open Meetings Act?
No, that one is out of a Court of Appeals case from the late 1980s.
Okay, and that was the one that, is that the Coat versus Drake, I believe, that you...
I just turned the page away from it, so...
From that opinion that you got.
Yes.
So,
Coates and then City of Detroit versus Gorno Steel. And the principle there, the reason I quoted those for you is that it's very clear to me that a city attorney doesn't have any independent authority as the city attorney to go out and settle cases for the city. The city has to give authority to settle a case or cases. that much is clear. In your particular setting, you folks had a closed session meeting in which everybody seems to agree there was you went into closed session to discuss the strategy of this case. That was the discussion in it. You can't have a decision in a closed meeting. The Open Meetings Act doesn't allow you to do it. So you had to come out of that closed session, and if you were going to make a decision to settle the case, you should have done it in open session right afterwards, which didn't happen.
And it still hasn't happened.
Just didn't happen. That means only one thing to me, is that there's been no formal decision by this city council to settle the case. Just
But it's
never
signed
did
and
it.
it's settled.
It's settled over in federal district court.
That's right, I know.
So my recommendation was, just as the law allows, subsequent ratification is a recognized way to clear that up. In other words, the city council can still vote to ratify the settlement, and then that closes the loop on what is otherwise unclosed.
What if that's not our wish?
Then you don't do it. You just put it to a vote, and you either ratify it or not.
So a subsequent action would allow us to be in compliance with the Open Meetings Act, is what you're saying?
It isn't so much, now it's not so much an Open Meetings Act question as much as it is whether you really want to ratify the settlement or not.
No.
You couldn't have done it yet. You just haven't done it in an open meeting, so it hasn't happened.
No, and
You can still do it. I think for the benefit of your constituents, the members of the public, that at some point you ought to put it to a vote.
Well, may I ask you, do you think that our city attorney who signed that agreement without our knowledge should have been aware of the information that you just gave us?
I'm sure he's aware of the general practice in Michigan and standards. He explained to me that the actual practice here in Lincoln Park had been to brief the city council and settle cases, and you don't come back and get formal expression of authority, and had not.
Well, does generally cases of this nature require outside, if your insurance legal counsel is there representing municipality, they went one step further in this case. They asked for city officials to acknowledge that they have discussed this, that they have read this, their attorneys of record have went over, and additional signatures of city officials. And that's a new one that I'm seeing, that from the cases that I've read, I haven't seen that.
I missed the question.
Where the plaintiff actually required additional, when our insurance carrier could have settled the case, whether we liked it or not, they could have settled the case.
I think that's correct.
Okay, so they went one step further, and they said, you know what, we don't want to just do that. We want to make sure your city officials have read this agreement, their counsel has explained it to them, and they further authorized Mr. Duchesne and Mr. Zelenak to sign it. Is that something you see commonly done? Because I haven't seen that.
I'm not sure I've seen it commonly. I have seen it, and I have seen it in particular in the land use type cases where cautious attorneys will insist that the municipality somehow certify that they've done what they're supposed to actually settle it. It's an open question as to what happens when they haven't, like what you folks have gone through. Some judges will want to see that in a proposed consent judgment because they've been through it with a municipality before, and they've heard rumblings that maybe a municipality didn't agree. So they'll say, I want to make sure that municipality has agreed. I either put that in the judgment, or in some odd situations, there are stories, it's never happened to me, stories of judges requiring a city council to hold session at the courthouse in order to formally give settlement approval to a case. Because the courts sometimes tire of attorneys showing up and saying, well, I don't have approval to do this. I just don't know what I can do. And some judges say, well, look, you either get the authority beforehand or you bring them in here and we'll have a public meeting on site. So the problem of getting local governmental approval of settlements is a practical problem that occurs in many ways, many forms. Your situation there is not unique. For whatever reason, past practice here developed in a way where you didn't finalize your settlement authority on the record. it's not a preferred practice to do it that way.
We've asked several times for documentation from Mr. Zelenak, and we haven't had any forthcoming. And last night, Councilman Mike Myers was told that Mr. Zelenak was not going to provide that. And he further said just last night that your report stated that he was authorized to sign the settlement agreement. And I've went over that, and your report says to me, Mr. Zelenak states he was authorized, not that he was authorized. And I do want to clear that up. And the information you just read to us basically says, no, that's not the case. He may say that he was, but that's not what I read in your opinion.
That part gets to you're correct, and it gets back to the Open Meetings Act question, because in the closed session, you can discuss settlement strategy and tactics, and you can authorize the attorney, yes, go out, try and settle, this is the way we want to do it. But what that does not involve is a formal decision to settle. That can't happen in closed session. You have to go into open session and do that. Still hasn't happened. Now, Mr. Zelenak may very well have heard, and that's what he says he heard in closed session, part of his settlement discussion and strategy with you folks was to settle the case. And so he thought he was supposed to go do that, and he took that as authorization. And that may be splitting hairs, but obviously you folks didn't ever vote to approve the settlement. That has to happen in open session. That's why I still think, in retrospect, you should still go through the step of subsequent ratification and get it over with. You know, to perpetuate it just to perpetuate it, I don't think serves any useful purpose. But it may be that there aren't 4 people on the council that will vote to ratify. That could happen. I don't think it gets you out of the case without going in front of the judge and asking to withdraw, and I just can't recommend it. I don't see that that helps you. I don't think you're going to get a better outcome, and I don't think you're going to get anything in particular out of going and ask the judge to get out of the case.
Hey,
Sorry. Sometimes Mr.
Mr. Williams.
Not yourself.
We should probably hit that one head on. If you're willing, I'm willing. A large substantive question posed by the city council to me was, should we undo it? Should we look at this settlement agreement and say it's a bad deal, we didn't really authorize it, we don't like it, let's ask the judge to let us out of it because we didn't authorize it, and let's go back to square one and let's see if we can get a different result. That was the big question.
Right.
The way I look at it, number one, I don't think you're going to get a better result by undoing it and starting over. And number two, I think you'll spend a bunch of money and you'll agonize over the ongoing litigation without getting a materially better result. And number three, I think you will raise false expectations or unwarranted expectations in your constituents, that you might get them something, a victory of some sort that you're really not likely to get. And that is just not good government, to say we're going to fight a lawsuit for the sake of fighting it if there's no meaningful opportunity or likelihood of getting a different result. That's kind of harsh analysis. Sometimes it's nice to have a fight to uphold principle, but if there's no legal basis to stop the business from coming in the form that is proposed, that's a waste of public money on a goal that can't be achieved. When I looked at this, if I had thought or I saw a way to perhaps stop the business that was coming in, then I would agree with those of you who question seriously whether this should happen at all, and say maybe you did give away the farm. Maybe you should be trying to set it aside. I don't see any legal basis for stopping this business from opening its doors in the proposed form.
And I don't think that was ever the consensus of the council. Even when we sent our legal counsel to go ahead and negotiate a settlement, it wasn't with the intent of prohibiting the business to open, but we have to think outside the box. We can't just think, okay, this is a good settlement, this is good for right now, and this didn't cost us any money, because we have the long-term effects to think about for the city.
And I agree, and I think that's the correct approach. But I'm not sure I don't think that discussion has happened yet at the council table in front of your public and your constituents because of the way this case unfolded. And I think that contributes to the anxiety, the frustration, the worry. You know, people think maybe you're not doing your job because you didn't ask those tough questions. You didn't ask and get an opinion as to whether or not it's worth it to go forward. I don't believe in this profession, I don't believe in playing cheerleader for the sake of saying what people want to hear. Some people do that. In other words, would encourage you, let's fight the lawsuit as long and as hard as you can. Maybe we can do this, maybe we can do that, without giving you a candid assessment. But I don't think that helps. I don't think it helps you make a good informed decision, and I don't think it helps your constituents understand the legal framework in which you have to operate. There are limits as to what you can do as a municipality. I didn't see a good opportunity here to stop the business, number one. And I understand your point that you folks apparently weren't thinking about stopping the business at all. It was more a question of making sure they followed the rules.
Right.
And that's a worthwhile consideration. There isn't anything wrong with that.
And that's why I was asking you at the start of our discussion tonight where to go from here, because that is primarily my concern, because I whether they open their doors, I want it to the least amount of impact on our residents, the least amount possible. And I thought I had really accomplished that with the adult cabaret. I thought, okay, I don't care what happens after this. Anybody who comes in, I think I've covered it. And I don't want to be negligent in my obligations.
It was a good step. The sad reality of what municipalities face, though, in this arena is it's just never over. The process of reviewing what you have, looking to see if you need to adopt more, looking to see if you need to amend, looking to see if it's working out in the community or if you've just adopted it and nothing's happened, that goes on, and it just never ends. It's part of the overall process. You folks are a little more ahead of the game in terms of paying attention to it than a lot of communities. I often get called by communities who don't have any ordinances in place, or they haven't looked at them in years or used them in years, and they're faced with the threat of incoming businesses. They don't know how to apply them, they don't know how to react, and they're way behind the curve. You folks are in there. You still have some of the regulations left to enforce. Obviously, there's been a loss on part of them. I just don't think it's such a loss that you, as a city, should back up and start over on that lawsuit. I think it's time to continue what you're already starting to do, which is examine what you have, what you can do, what more you can do. And I go back to the idea, which is really, you keep heading on to the next step. I go back to the idea that if you look at your regulatory package and you see that there are more ordinance regulations you think you need to adopt, and if you think this particular settlement agreement somehow impairs or limits that, I would take a specific one and I'd go back to these folks and say, look, this is what we want to do. We want to make sure you guys don't think it's in violation, or if you do, we want to negotiate our way through it and show you what we want to adopt, and we still want to get it done. And if you want to pick a fight on a regulatory issue, I'd pick that fight on one that you know you really think fits your town, that you need, that you want. And if those folks are going to block it, then that's one I'd go toe-to-toe on. You know, select the issue that you really think you need, show it to them and see if it's one that really bothers them or not. You may find that it doesn't. Or you may find one that if it does affect them, they may be willing to concede. You don't know until you do your homework and go to them. But I wouldn't look at this as a closed book that you never can reopen.
And I don't want to, I'm done with my part of the questions, but please make sure that, I'm going to let everybody, I've been talking for far too long, but please make sure to come back to the problematic areas that you were kind of touching on, because the more input we get from you, the better off we are.
I'll give you that short version right now.